I see we have Grantmeyer now. Do we want to check his audio?
Please do.
Can you hear me?
We can hear you.
We can hear you.
We'll just need you to either lower your camera or sit back a little bit. We just can't see your face. There we go. You're on mute.
All right, is Mr. Grantmeyer set up?
Yes, I
I
think we're
believe
good to
I'm all
go.
set up.
Okay. All right, everyone, it's 2 o'clock, so let's go ahead and get started. Good afternoon. Let's come to order, please, and go on the record. I'm Charlotte Mitchell, Chair of the North Carolina Utilities Commission. And with me this afternoon are the following commissioners. When I call your name, please indicate your presence. Commissioner Tanola D. Brown Bland.
I'm here.
Commissioner Lyons Gray.
I'm here.
Commissioner Daniel G. Clodfelter.
Yes, good afternoon.
Commissioner Kimberly W. Duffley.
Good afternoon.
Commissioner Jeffrey A. Hughes.
Here.
And Commissioner Floyd B. McKissick, Jr.
Here.
I now call for hearing docket number E7, sub 1214, the application of Duke Energy Carolinas for an adjustment of rates and charges applicable to electric utility service in North Carolina. Docket number E7, sub 1213, which is the petition of Duke Energy Carolinas for approval of its prepaid advantage program. Docket number E7, sub 1187, which is the application of Duke Energy Carolinas for an accounting order to defer incremental storm damage expenses incurred as a result of Hurricanes Florence and Michael and Winter Storm Diego. Docket number E2, sub 1219, which is the application of Duke Energy Progress for an adjustment of rates and charges applicable to electric utility service in North Carolina. And docket number E2, sub 1193, which is the application of Duke Energy Progress for an accounting order to defer incremental storm damage expenses incurred as a result of Hurricanes Florence and Michael and Winter Storm Diego. On December 21st, 2018, Duke Energy Carolinas filed an application in docket number E7 sub 1187 requesting that the commission approve the deferral of DEC's cost of restoring electric service after Hurricanes Florence and Michael and Winter Storm Diego. Also on December 21st, 2018, Duke Energy Progress, DEP, filed an application in docket number E2 sub 1193 requesting that the commission approve the deferral of DEP's cost of restoring electric service after Hurricanes Florence and Michael and Winter Storm Diego. On August 2nd, 2019, DEC filed a petition for approval of its prepaid advantage program in docket number E7 sub 1213, pursuant to which DEC would offer customers the billing option to prepay for service. On September 30th, 2019, DEC filed an application with the Commission in docket number E7 sub 1214, requesting authority to adjust and increase its rates for retail electric service in North Carolina. On October 29th, 2019, the Commission issued its order establishing general rate case, suspending rates, scheduling hearings, and requiring public notice. On November 20th, 2019, the Commission issued an order consolidating dockets number E7 sub 1213 and sub 1214 that consolidated DEC's petition for approval of the prepaid program with DEC's rate case application. On June 26, 2020, the Commission issued an order consolidating dockets and docket numbers E7 sub 1214 and E7 sub 1187 that consolidated DEC's application for deferral of its storm costs with DEC's general rate case application. On October 30th, 2019, DEP filed an application with the Commission in docket number E2 sub 1219, requesting authority to adjust and increase its rates and charges for retail electric service in North Carolina. On November 14th, 2019, the Commission issued its order establishing general rate case and suspending rates. And on December 26, 2019, the Commission issued an order scheduling investigation and hearings, establishing intervention and testimony due dates and discovery guidelines, and requiring public notice. On August 11th, 2020, the Commission issued an order consolidating dockets number E2 sub 1219 and sub 1193 that consolidated DEP's application for deferral of its storm cost with DEP's general rate case application. On March 10th, 2020, Governor Roy Cooper issued an executive order declaring a state of emergency in North Carolina to coordinate response and protective actions to prevent the spread of the novel coronavirus, COVID-19. In doing so, the governor ordered state agencies to cooperate in the implementation of the provisions of the executive order. By subsequent executive orders, the governor restricted non-essential movement of the state's residents and ultimately prohibited gatherings of certain numbers of persons in order to limit the spread of COVID-19. On March 16, 2020, in response to the COVID-19 pandemic and the governor's declared state of emergency, and upon the motion of DEC, the Commission issued an order postponing hearing and addressing procedural matters in docket number E7 sub 1214. Pursuant to the October 29, 2019 order in that docket, the expert witness hearing had been scheduled to begin on March 23, 2020. In its motion, DEC waived its right to implement its proposed rates by operation of NCGS Section 62-134 in the event that the postponement of the hearing renders it infeasible for the Commission to issue an order prior to the expiration of the rate suspension period. On March 24th, 2020, in response to a request by the public staff for an extension of time to file testimony, the Commission issued an order suspending the procedural schedule and continuing the hearing in docket number E2 sub 1219, sua sponte suspending the procedural schedule and continuing the expert witness hearings scheduled to begin on May 4th, 2020, due to the continuing uncertainty surrounding the COVID-19 pandemic. On March 25th, 2020, DEC and the public staff filed their first agreement and stipulation of partial settlement. In a filing made on April 3rd, 2020, DEP waived its rights to implement its proposed rates by operation of NCGS Section 62-134 through December 31st, 2020, in the event that the postponement of the hearing renders it infeasible for the Commission to issue an order prior to the expiration of the rate suspension period under Section 62-134. On June 2nd, 2020, DEP and the public staff filed their first agreement and stipulation of partial settlement. On June 17, 2020, the Commission ordered that the expert witness hearings and the above captioned proceeding would be consolidated for hearing beginning on Monday, July 27th at 2 p.m. solely for the purpose of considering testimony on topics for which the evidence is identical and equally admissible as to DEC and to DEP, and additionally, that this consolidated hearing would be conducted remotely. Thereafter, on July 27th, 2020, in response to a joint motion of the public staff and the companies, the Commission issued an order further rescheduling the consolidated remote hearing. Among other things, the Commission ordered that the consolidated hearing be rescheduled to begin at 2 o'clock in the afternoon on Monday, August 24th, 2020. On July 31st, 2020, DEC and the public staff and DEP and the public staff filed their second agreements and stipulations of partial settlement along with supporting testimony. On August 6th, 2020, the Commission issued its order approving DEP's public notice and financial undertaking relating to DEC's exercise of its statutory right to place into effect temporary rates pending a final order by the Commission approving permanent rates. Similarly, on August 11th, 2020, the Commission issued its order approving DEP's public notice and financial undertaking relating to DEP's exercise of its statutory right to place into effect temporary rates pending a final order by the Commission approving permanent rates. The Commission has allowed intervention in these dockets upon petitions filed by each of the following parties: and dockets number E2 sub 1219, E7 sub 1213, and E7 sub 1214, Harris Teeter, NC SEBA, and the North Carolina League of Municipalities. And docket number E2 sub 1214, Carolina Industrial Group for Fair Utility Rates 2, the Department of Defense and all other federal executive agencies, the Fayetteville Public Works Commission, and Hornwood, Inc. And E7 sub 1214, Apple Inc., Facebook Inc., and Google Inc., otherwise referred to as the tech customers, the Carolina Industrial Group for Fair Utility Rates 3, and the Center for Biological Diversity and Appalachian Voices. And E2, and docket number E2 sub 1219 and E7 sub 1214, the Carolina Utility Customers Association, Inc., the Commercial Group, the North Carolina Justice Center, the North Carolina Housing Coalition, the Natural Resources Defense Council, and the Southern Alliance for Clean Energy. NC Warren, Inc., the North Carolina Sustainable Energy Association, the Sierra Club, and Vote Solar. Numerous statements of position have been received and filed in each of the respective dockets. In addition, both DEC and DEP have entered into partial settlements with SIGFR, Vote Solar, Commercial Group, Harris Teeter, jointly with NCSEA, the North Carolina Justice Center, the North Carolina Housing Coalition, the Natural Resources Defense Council, and the Southern Alliance for Clean Energy. That brings us to the hearing, which we will begin today. There will be one official record for this consolidated hearing. The record of the consolidated hearing will be considered part of the official records for each of the separate DEC and DEP proceedings. Issues not heard during the consolidated hearing will be heard in the separate expert witness hearings to be convened subsequent to this consolidated hearing. The Commission has identified the following topics that will be considered during this consolidated hearing. First, the capital structure of the utilities to be used to determine the overall weighted average cost of capital. Second, the rate of return on common equity. Third, the cost of debt. Fourth, credit quality. Fifth, the treatment of excess deferred income taxes. Sixth, the grid improvement plan. And seventh, affordability. Before we get started today, I want to make a few points on the record in light of the fact that this hearing is being conducted remotely. This hearing has been made accessible to the public by way of an access link that's been provided on the Commission's website. Each of the parties here too has consented to the Commission's conducting this hearing by remote means, as evidenced by the parties' filings in these dockets. In addition, Duke has filed a letter in these dockets on July 21st, 2020, confirming that all parties had filed a statement of consent to hold these hearings remotely. In the interest of ensuring the efficient use of hearing time and minimizing the potential for technical difficulties, the Commission has provided multiple opportunities for the parties to verify that they're able to access the remote technology utilized by the Commission for this hearing, including technology checks conducted on July 21st, July 22nd, and July 24th. Going forward, we ask that parties connect to the remote technology well in advance of the point in time at which we will go on the record. At the beginning of the day, you'll be able to connect 30 minutes prior to our going on the record in order to check your connection. And throughout the course of a day, the link to the hearing will remain live, so you should have no problem rejoining the hearing once we have begun. Due to the fact that this hearing is being held remotely, parties have been asked to avoid the use of confidential information to the greatest extent possible. In the event that a party must reference confidential information, we'll leave the video conference and join a teleconference line. The party whose confidential information is being discussed is responsible for ensuring that only those parties who have executed confidentiality agreements are on the teleconference line. When the discussion of the confidential information is complete, we will leave the teleconference line and return to the video conference. Although we are connected through the video conference technology and not sitting in our hearing room together, it's the Commission's expectation that this hearing be conducted as if we were present in the hearing room. This means that we must maintain order and not interfere with our court reporter's ability to transcribe this hearing accurately. Please do not unmute your microphone if you are not speaking. If you must speak out of turn, please indicate your name first. Okay, now let's go ahead and get started. Pursuant to the State Ethics Act, I remind all members of the Commission of their duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has a known conflict of interest with respect to the matters that will come before us.
No.
Okay, please let the record reflect that no conflicts have been identified. So we will proceed. I now call upon the parties to announce their appearances, beginning with the applicants.
Good afternoon, Chair Mitchell, members of the commission. My name is Kamal Robinson, appearing on behalf of Duke Energy Carolinas and Duke Energy Progress. Also appearing with me from Duke are Mr. Bo Summers and Mr. Brian Heslin. Additionally, we have appearing with us from the law firm of Troutman Pepper, Kiran Mehta, Molly Jagannathan, and Brandon Marzo. Mr. Marzo is a member of the Georgia Bar and has pro hoc vice motions granted for appearance in this proceeding. We also have appearing from the law firm of McGuire Woods, Jim Jeffries, and Andrea Kells. All of our attorneys have filled out appearance sheets and have provided them previously to the court reporter.
Okay, thank you, Mr. Robinson. We will now hear from the interveners, beginning with the public staff.
Good afternoon, Chair Mitchell. Diana Downey, Chief Counsel with the Public Staff. Appearing with me during the course of this hearing will be the following attorneys from the public staff: Elizabeth D. Culpepper, William E. Grantmeyer, Layla Cummings, Tim R. Dodge, Lucy E. Edmonton, Gina C. Holt, Megan Yost, John D. Little, and Nadia L. Moore.
Okay, thank you, Ms. Downey. All right, the Attorney General's office.
Good afternoon. My name is Margaret Force. Appearing with me is Teresa Townsend, appearing for the Attorney General's office on behalf of the using and consuming public.
Good afternoon, Ms. Force. All right, Kuka.
Good afternoon, Madam Chairman and Commissioners. I'm Robert Page, representing Carolina Utility Customers Association.
Good afternoon, Mr. Page. Sigfer.
Good afternoon, Chair Mitchell and Commissioners. This is Christina Kress with the law firm of Bailey and Dixon. I represent the Carolina Industrial Group for Fair Utility Rates 2 and 3, collectively referred to as SIGFR. Thank you.
Good afternoon, Ms. Kress. Center for Biological Diversity and Appalachian Voices.
Good morning, Chair Mitchell and Commissioners. My name is Jean Sue with the Center for Biological Diversity, and I am here representing the Center for Biological Diversity and Appalachian Voices.
Good afternoon, Ms. Sue. The Commercial Group.
Good afternoon, Commissioners. Alan Jenkins for the Commercial Group of the law firm Jenkins at Law, LLC, and also Brian Beverly of Young, Moore, and Henderson, PA.
Good afternoon, Mr. Jenkins. The Department of Defense.
Good afternoon, Chair Mitchell. This is Emily Medlin on behalf of the United States Department of Defense and all other federal executive agencies.
Good afternoon, Ms. Medlin. Fayetteville Public Works Commission. Harris Teeter.
Good afternoon, Chair Mitchell. My name is Kurt Boehm, appearing on behalf of Harris Teeter. I'd also like to enter the appearances of Jody Kyler Cohn and Ben Royster.
Good afternoon, Mr. Boehm. Hornwood, Inc.
Good afternoon. This is Janessa Goldstein on behalf of Hornwood, Inc.
Good afternoon, Ms. Goldstein. The North Carolina Justice Center.
Good afternoon, Chair Mitchell and members of the Commission. This is Gudrun Thompson with the Southern Environmental Law Center, appearing on behalf of the North Carolina Justice Center, North Carolina Housing Coalition, Natural Resources Defense Council, and Southern Alliance for Clean Energy. And with me are my co-counsel, also with Southern Environmental Law Center, David Neal and Tyrell Moore.
Good afternoon, Ms. Thompson. NC Warren.
Good afternoon, Chair Mitchell and members of the Commission. My name is Matthew Quinn. I am with the law firm of Lewis and Roberts, and I am here on behalf of NC Warren. Thank you.
All right, NC SEBA.
Good afternoon, Chair Mitchell and members of the commission. My name is Karen Kimmerite, and I'm here on behalf of the North Carolina Clean Energy Business Alliance.
Good afternoon, Ms. Kimmerite. All right, the North Carolina League of Municipalities. The North Carolina Sustainable Energy Association.
Good afternoon, Chair and Commission. This is Ben Smith representing the North Carolina Sustainable Energy Association. With me as co-counsel is Peter Ledford, also of the North Carolina Sustainable Energy Association.
Good afternoon, Mr. Smith. The Sierra Club.
Good afternoon, Chair Mitchell and members of the Commission. My name is Bridget Lee of the Sierra Club Law Program, appearing on behalf of Sierra Club. And appearing with me today is Catherine Crowley-Jones of the law offices of Brian Bryce.
Tech Customers.
Good afternoon, Chair Mitchell and Commissioners. I'm Marcus Trathan with the law firm of Brooks Pierce, appearing on behalf of the tech customers, Apple, Facebook, and Google. Also appearing for tech customers are my colleagues, Craig Schauer and Matt Tynan. Thank you.
Good afternoon, Mr. Trathan. All right, and Vote Solar.
Good afternoon, Chair Mitchell and members of the Commission. This is Thad Cully, counsel for Vote Solar. Thank you.
Good afternoon, Mr. Coley. All right, any preliminary matters that the commission needs to take up before we move into the hearing?
Chair Mitchell, this is Kamal Robinson. Yes, the companies have 3 matters to bring up, and I'll start whenever you're ready.
Okay, please proceed, Mr. Robinson.
Sure. Chair Mitchell, at this time, we ask that the company's applications be entered into the respective DEC and DEP records, and then copied into those records at the appropriate time.
Okay, hearing no objection, Mr. Robinson, that motion will be allowed.
Thank you, Chair Mitchell. In addition to that, I should have included with the company's applications, the company's Form E1s as well, to be copied into both the DEC and DEP records.
And that motion is allowed.
Thank you. Second thing, Chair Mitchell, we also have, as you mentioned, a number of settlement agreements to be entered into the DEC and DEP records and then copied into those records at the appropriate time. I can list them now if you would like.
Please do so, Mr. Robinson.
Sure. I'll start with DEC first. DEC agreement and stipulation of partial settlement with the public staff filed on March 25th, 2020. DEC settlement agreement with Harris Teeter, LLC, filed on May 28th, 2020, and amendment filed on August 6th, 2020. DEC agreement and stipulation of settlement with SIGFR, filed on May 29th, 2020, an amendment filed on August 6th, 2020. DEC settlement agreement with the commercial group filed on June 1st, 2020, an amendment filed on August 5th, 2020. DEC agreement and stipulation of settlement with Vote Solar filed on July 9th, 2020, an amendment filed on August 5th, 2020. DEC agreement and stipulation of settlement with NCSEA, NCJC, NCHC, NRDC, and SACE, filed on July 23rd, 2020, an amendment filed on August 10th, 2020. And DEC second agreement and stipulation of partial settlement with the public staff, filed on July 31st, 2020. Those are the DEC agreements, Chair Mitchell. I will move on to the DEP.
Mr. Robinson, let's go ahead and move those agreements into the DEC record. I've heard no objection, so your motion to move those into the record will be allowed.
Thank you, Chair Mitchell. Now for DEP. DEP agreement and stipulation of partial settlement with the public staff, filed on June 2nd, 2020. DEP settlement agreement with Harris Teeter, LLC, filed on June 8th, 2020, an amendment filed on August 6th, 2020. DEP agreement and stipulation of settlement with SIGFR, filed on June 26th, 2020, and amendment filed on August 6th, 2020. DEP settlement agreement with the commercial group filed on June 9th, 2020, and amendment filed on August 5th, 2020. DEP agreement and stipulation of settlement with Vote Solar filed on July 9th, 2020, and amendment filed on August 5th, 2020. DEP agreement and stipulation of settlement with NCSEA, NCJC, NCHC, NRDC, and SACE filed on July 23rd, 2020, and amendment filed on August 10th, 2020. And DEP second agreement and stipulation of partial settlement with the public staff filed on July 31st, 2020. The company moves for those to be entered into the record and copied at the appropriate time.
And hearing no objection, Mr. Robinson, your motion's allowed.
Thank you, Chair Mitchell. And I have one last thing on behalf of the companies. So Chair Mitchell, due to the number of documents that have been pre-filed in this case, from time to time, our witnesses and attorneys will be receiving help from assistance to quickly locate exhibits to minimize disruption to the flow of the hearing. I just wanted to alert the commission of this intended practice in advance and ensure the commission and the parties that the role is a purely administrative one.
Understood, and thank you, Mr. Robinson, for that, for letting us know.
Thank you, Chair Mitchell. That's all I have on behalf of the companies.
Okay. Any additional matters before we begin?
Diana Downey here, Chair Mitchell.
All right, Ms. Downey.
I just want to alert the commission, although I don't expect it to happen during this consolidated portion of the hearing, I do believe that confidential material will need to be discussed during the separate hearings. I just wanted to bring that to your attention, and as we get closer, I believe it's going to be primarily in the coal ash testimony, but I just wanted to alert you to that.
Okay, thank you very much. And as I stated in my opening remarks, if and when it becomes necessary to discuss confidential information, we will leave the video conference and we will join a teleconference line. That line has been or will be provided to the parties that have executed NDAs or confidentiality agreements. And we will remain on the telephone line through the discussion of confidential information and then return to the video conference once that discussion has ceased. It's incumbent on the parties to let us know, to let me know when when we are approaching that point at which confidential information may need to be discussed. So I will call on all of us to be vigilant about that, because we need to obviously exit the video conference, and we'll have to get on the phone line. Okay, anything else, Ms. Downey, or any of the other?
I'm sorry, another matter, Chair Mitchell. We have at least one excused witness in this consolidated portion of the hearing. Just need some guidance as to when you would like for us to introduce their testimony to the record.
Ms. Downey,
I missed what she said there at the end.
I just wanted to know the appropriate time to ask that their testimony be introduced.
Ms. Downey, since you're before me now, go ahead and move that testimony in.
Okay, yes, ma'am. This is with respect to public staff witness Randall Woolridge in the DEC docket E7 sub 1214. I move that the testimony of J. Randall Woolridge filed February 18, 2020, consisting of 131 pages and an Appendix A with 10 exhibits, JRW1 through 10. Supplemental testimony filed March 25th, 2020, consisting of 4 pages with 1 exhibit. Supplemental exhibit JRW-1. Supplemental testimony supporting second partial stipulations filed July 31, 2020, consisting of 11 pages, be entered into the record in this proceeding and copied into the record as if given orally from the stand in the DEC rate case dockets at the appropriate time.
All right, Ms. Downey, hearing no objection to your motion will be allowed.
And then with respect to the testimony in the DEP rate case E2 sub 1219. I move that the testimony of J. Randall Woolridge, filed April 13, 2020, consisting of 146 pages and appendices A and B with 10 exhibits, JRW 1 through 10, and supplemental testimony supporting second partial stipulations, filed July 31, 2020, consisting of 11 pages, be entered into the record in this proceeding and copied into the record as if given orally from the stand in the DEP rate case dockets at the appropriate time.
Thank you, Ms. Downey. Hearing no objection, your motion is allowed. Any other preliminary matters? Hearing none, the case is with Duke.
Thank you, Chair Mitchell. This is Kiran Mehta. And at this time, Duke Energy Carolinas and Duke Energy Progress would call witnesses Dylan Diascendis and Carl Newland to the stand to testify as a panel.
Good afternoon, Mr. Mehta. And let's go ahead and affirm the witnesses. All right, gentlemen, let me know when you are ready.
Ready. Ready, Chair.
Okay. Do you all affirm the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth?
I do. I do.
All right. Thank you very much.
Thank you, Chair Mitchell. Mr. Diascendis, why don't we start with you? Would you please state your name and business address for the record?
Sure. My name is Dylan, D-Y-L-A-N, Diascendis, D-A-S-C-E-N-D-I-S. And my business address is 3000 Atrium Way, Suite 200 in Mount Laurel, New Jersey, 08054.
And by whom are you employed and in what capacity?
I'm a director at Scott Madden, Inc.
Mr. Diascendis, on June 29th, 2020, did you cause to be pre-filed in docket E7 sub 1214 direct testimony consisting of 97 pages, as well as an attachment A and 7 exhibits to that testimony?
Yes.
Did you also, on that day, cause to be pre-filed in that docket rebuttal testimony consisting of 197 pages as well as 23 exhibits?
That's right.
Do you have any changes or corrections to your pre-filed direct or rebuttal testimony in docket E7 sub 1214?
Yes, I have one in my rebuttal testimony on page 20, line 14. I would strike 9.90% and replace that with 9.70%. And that's the entirety of my corrections.
And with the correction you just noted, if I asked you the same questions here today, would your answers be the same?
They would.
On June 29th, 2020, did you cause to be pre-filed in docket E2 sub 1219, the Duke Energy Progress docket, direct testimony consisting of 100 pages, as well as an attachment A and 7 exhibits to that testimony?
I did.
Did you, on July 7th, 2020, cause to be pre-filed in that docket, the Progress docket, amended rebuttal testimony consisting of 235 pages, as well as an Appendix A and 25 exhibits?
I did.
Do you have any corrections or changes to your pre-filed direct or amended rebuttal testimony in docket E2 sub 1219?
I do, just one for the rebuttal testimony, at page 47, line 7. Again, it's a strike 9.90% and replace it with 9.70%.
And with that correction you just noted, if I asked you the same questions here today, would your answers be the same?
They would.
In addition, Mr. D'Ascendis, did you on July 20th, 2020, cause to be pre-filed in both docket E7 sub 1214 and docket E2 sub 1219 supplemental rebuttal testimony consisting of 24 pages along with 8 exhibits?
I did.
Do you have any changes or corrections to the testimony or exhibits in your supplemental rebuttal testimony?
I do not.
Finally, Mr. D'Ascendis, did you on July 31st, 2020, cause to be filed in each of docket E7 sub 1214 and docket E2 sub 1219 settlement supporting testimony consisting of, in each docket, 9 pages along with 1 exhibit?
I did.
Do you have any changes or corrections to the testimony in your settlement supporting testimony in either docket?
I do not.
Chair Mitchell, I move that Mr. D'Ascendis's pre-filed testimony in docket E7 sub 1214 as previously described and consisting of direct, including Appendix A, rebuttal as corrected, supplemental, and settlement supporting testimony be entered into the record in this proceeding, and further move that at the appropriate time that testimony be copied into the record as if given orally from the stand in the Duke Energy Carolinas rate case dockets.
All right, hearing no objection to your motion, Mr. Mehta, it will be allowed.
Thank you, Chair Mitchell. I request further that Mr. D'Ascendis's exhibits attached to his Duke Energy Carolinas testimony be marked for identification as pre-marked.
They will be so marked.
Further, Chair Mitchell, I move that Mr. D'Ascendis's pre-filed testimony in docket number E-2 sub 1219 as previously described and consisting of direct, including Appendix A, amended rebuttal as corrected, including Appendix A, supplemental and settlement supporting testimony be entered into the record in this proceeding, and further move that at the appropriate time that testimony be copied into the record as if given orally from the stand in the Duke Energy Progress rate case dockets.
Hearing no objection, Mr. Mehta, your motion will be allowed.
Finally, Chair Mitchell, I request further that Mr. D'Ascendis's exhibits attached to his Duke Energy Progress testimony be marked for identification as pre-marked.
They will be so marked.
Mr. D'Ascendis, do you have a summary of your testimony?
I do.
Please give that summary to the commission.
Sure. The purpose of my direct testimony is to estimate the company's return on equity, sometimes referred to as ROE or cost of equity. Although my testimony necessarily discusses the financial models used to estimate the cost of equity, I also address other issues that are important in developing ROE recommendations. In particular, I address capital market conditions and the effect of those conditions on the return that investors require in order to commit their capital to equity securities. My testimony also addresses business risks facing utilities such as Duke Energy Progress and Duke Energy Carolinas, and the importance of maintaining a financial profile that enables the companies to access the capital markets when and as needed. Based on those analysis, my direct testimony recommended a range of 10% to 11% with a specific ROE recommendation of 10.50%. The cost of equity is the return investors require on investments of comparable risk. Like the interest paid on debt, the required return on equity is a cost set by investors in competitive capital markets. Unlike the cost of debt, which can be observed in the interest rates required by investors, the cost of equity is neither directly observable or contractually defined. Estimating the cost of equity therefore requires the careful application of various financial models and observable market data. In my direct and rebuttal testimonies, I discussed the fact that all models used to estimate the cost of equity are subject to their own set of assumptions and limitations. I note that as market conditions change, the ability of each model's ability to reasonably estimate the cost of equity also changes. That is, as markets change, the relevance of any given model may also change. Quite simply, a model that may have been reliable under one set of market conditions may become less reliable under a different set of conditions. It is therefore important to understand each model's underlying assumptions and to assess the extent to which they are applicable or not in the prevailing capital market. My rebuttal testimony responds to the opposing witnesses' recommendations as they relate to the company's cost of equity and capital structure. There are several areas where I disagree with the opposing witnesses' analytical methods and conclusions, and I address those issues in detail throughout my rebuttal testimony. In summary, none of their arguments caused me to revise my conclusions or recommendations. My supplemental rebuttal testimony responds to Attorney General witness Baldino regarding capital markets current and expected, and their effect on the cost of equity. Again, none of Mr. Baldino's arguments caused me to revise my conclusions or recommendations. My settlement testimony explains my support for the partial settlements as it relates to the return on equity and capital structure. I explained that although the stipulated ROE of 9.60% is somewhat below the lower bound of my recommended range, and while it remains my position that in a fully litigated proceeding, a range of 10% to 11% would represent a reasonable and appropriate measure of the company's cost of equity, I also recognize that the partial settlements represent the give and take among parties regarding multiple otherwise contested issues. If it is the company's determination that the partial settlements are a constructive resolution of the ROE and capital structure, I appreciate and respect that decision. My settlement testimony also explains the importance to rating agencies of the regulatory environment's support of credit, and notes that North Carolina is generally considered to have a constructive regulatory environment. Since 2016, the average authorized ROE for vertically integrated electric utilities has been 9.74%, 14 basis points higher than the settlement ROEs in this proceeding or in these proceedings. Among jurisdictions that, like North Carolina, is seen as having constructive regulatory environments, the average authorized ROE was 9.91%, 31 basis points over the 9.60% settlement ROEs. In view of returns authorized in regulatory jurisdictions in general and in constructive regulatory jurisdictions such as North Carolina, the settlement ROEs are a somewhat conservative measure of the company's cost of equity. Similarly, a 52% settlement equity ratio falls well within the range of those approved in more constructive regulatory jurisdictions, equivalent to the median approved equity ratio. Additionally, the 6.93% for Duke Energy Progress and 7.04% for Duke Energy Carolina overall rates of return included in the partial settlements are quite low. They fall in the bottom 33rd percentile of the 105 authorized returns for vertically integrated electric utilities since 2016. I note that the company's comparatively low cost of debt contributes to the low overall rate of return, and that low cost of debt is supported by constructive regulatory jurisdictions. Because customer rates are set on the overall rate of return, I believe that the partial settlements strike the appropriate balance between customer and investor interests. Lastly, I understand and appreciate that the Commission must apply its informed judgment in arriving at its ROE determination in this and in all proceedings. I also appreciate that in setting the company's rates, the Commission must balance the interest of the company's customers and investors. And I appreciate that in doing so, the Commission considers the effect of changing economic conditions on the company's customers. In my settlement testimony, I discuss my updated analysis of economic conditions in North Carolina and the United States, which continues to support my conclusion as presented in my direct testimony that the regional economic challenges in North Carolina are substantially similar to those in the rest of the country, such that the market results of a nationwide proxy group remain applicable to the utilities. That concludes my summary.
Thank you, Mr. Diascendis. And Mr. Newland, turning over to you, would you please state your name and business address for the record?
My name is Carl W. Newland. My business address is 550 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as a Senior Vice President, Corporate Development and Treasurer.
Mr. Newland, on September 30th, 2019, did you cause to be pre-filed in docket E7 sub 1214 direct testimony consisting of 35 pages? 25 pages, excuse me.
Yes, 25 pages.
And did you on March 4, 2020, cause to be pre-filed in that same docket rebuttal testimony consisting of 36 pages, some portions of which are marked confidential?
Yes.
Do you have any changes or corrections to your pre-filed direct or rebuttal testimony?
Yes, in light of the fact that Mr. Diascendis was substituted in as a witness in place of Mr. Hebert, all references to the testimony and exhibits of Mr. Hebert in my pre-filed direct and rebuttal testimony should be noted as referring to the corresponding testimony and exhibits of Mr. Diascendis.
As corrected, if I asked you the same questions here today, would your answers be the same?
Yes.
And did you, on July 31st, 2020, cause to be pre-filed in docket E7 sub 1214 settlement supporting testimony consisting of 6 pages?
Yes.
Do you have any changes or corrections to your pre-filed settlement supporting testimony?
No.
If I asked you the same questions here today, would your answers be the same?
Yes.
On October 30th, 2019, did you cause to be pre-filed in docket E2 sub 1219 direct testimony consisting of 26 pages?
Yes.
And did you on May 4th, 2020, cause to be pre-filed in that docket rebuttal testimony consisting of 42 pages?
Yes.
Do you have any changes or corrections to your pre-filed direct or rebuttal testimony?
Yes. Again, in light of the fact that Mr. Diascendis was substituted in as a witness in place of Mr. Hebert, all references to the testimony and exhibits of Mr. Hebert in my pre-filed direct and rebuttal testimony should be noted as referring to the corresponding testimony and exhibits of Mr. Diascendis.
And as corrected, if I asked you the same questions here today, would your answers be the same?
Yes.
And did you, on July 31st, 2020, cause to be pre-filed in docket E2 sub 1219 settlement supporting testimony consisting of 6 pages?
Yes.
Do you have any changes or corrections to your pre-filed settlement supporting testimony?
No.
If I asked you the same questions here today, would your answers be the same?
Yes.
Chair Mitchell, I move that Mr. Newland's pre-filed testimony in docket number E7 sub 1214 as previously described and consisting of direct as corrected, rebuttal as corrected, and settlement supporting testimony be entered into the record in this proceeding, and further move that at the appropriate time, that testimony be copied into the record as if given orally from the stand in the Duke Energy Carolinas rate case dockets.
Hearing no objections to your motion, Mr. Mehta, it will be allowed.
Thank you, Chair Mitchell, and I further move that Mr. Newland's pre-filed testimony in docket number E-2 sub 1219 as previously described and consisting of direct as corrected, rebuttal as corrected, and settlement supporting testimony be entered into the record in this proceeding, and further move that at the appropriate time, that testimony be copied into the record as if given orally from the stand in the Duke Energy Progress rate case dockets.
Again, hearing no objections to your motion, it will be allowed.
Thank you, Chair Mitchell. Mr. Newland, do you have a summary of your testimony?
Yes, I do.
Please give that summary to the commission.
Good afternoon, Commissioners. My name is Carl Newland, and I'm the Treasurer of Duke Energy Carolinas and Duke Energy Progress, which I'll refer to collectively as the companies. My testimony generally addresses the company's credit quality, capital structure, and cost of capital, and their importance in supporting the company's credit ratings and financial objectives. The company's overall financial objectives are to maintain balance sheet strength with assured access to capital at a reasonable cost. The companies face substantial capital needs over the next several years, including significant capital outlays associated with the closure of coal ash basins. As capital-intensive businesses, the companies rely on third-party capital in order to build, maintain, and operate the critical infrastructure necessary to provide cost-effective, safe, environmentally compliant, and reliable service to our customers 24 hours a day and 365 days a year. Strong credit ratings and a fair and reasonable return to our debt and equity investors are vitally important to attracting this capital. The companies must compete for third-party capital in the credit markets. Investors, both debt and equity, have a variety of investment opportunities available to them and will invest elsewhere if they feel the expected return provided by a company is inadequate. Lower credit quality weakens a company's attractiveness as an investment opportunity relative to companies with higher credit quality and similar risk profiles. For this reason, it is critically important that companies maintain strong investment-grade credit quality to assure their financial strength and flexibility and ensure access to capital on reasonable terms. Crucially, the companies must access the capital markets and compete for capital in those markets under all manner of market conditions. This is the nature of regulated capital-intensive industries like electric utilities. The companies must be able to operate and maintain their businesses without interruption and refinance maturing debt on time, regardless of financial market conditions. The financial markets can experience periods of volatility, sometimes at extreme levels, as we have certainly seen in the recent weeks and months, and the companies must be able to finance their needs throughout such periods. Strong investment-grade credit ratings provide the companies with greater likelihood of access to the capital markets on reasonable terms during such periods of volatility. As I indicated in my Duke Energy Progress rebuttal testimony, the COVID-19 crisis roiled capital markets with high uncertainty and volatility, and we saw issuers with lower credit ratings and more stressed financial metrics experience greater borrowing costs, and in some cases, their access to the capital markets was foreclosed. As a result of the settlement agreements the companies have entered into with the public staff and other interveners, a number of issues I addressed in my direct and rebuttal testimony for each company have been resolved, pending commission approval. My testimony filed in support of the second settlement with public staff notes my credit quality assessment of the items resolved. It also notes, however, the potential credit quality impact of one of the principal unresolved issues, the company's ability to recover prudently incurred coal ash compliance costs, including financing costs inherent in spreading out that recovery over a multi-year amortization period. Should interveners' coal ash cost recovery positions be adopted by the commission, the end result will be a marked deterioration in the company's credit quality, which will inevitably lead to higher cost of capital as the companies seek to attract investors to fund their extensive capital needs. The deterioration in credit quality will be exacerbated by more favorable regulatory treatment afforded to utilities in neighboring jurisdictions. As I have indicated, investors vote with their wallets and will go elsewhere if the returns they see from the companies do not meet their requirements, or if they do not believe their credit quality will be maintained over the life of their investment. The deterioration of the company's credit quality comes about because the company's quantitative metrics, namely cash flow, will suffer. The quantitative metric credit rating agencies rely upon most heavily is FFO to debt. That is funds from operations, or cash flow, divided by debt outstanding. A reduction in the numerator of this ratio, cash flow or FFO, will result in a deterioration in the FFO to debt metric. Moody's calculation of Duke Energy Carolinas' FFO to debt ratio was 24.5% in 2018 and 24.6% through June 2019, and it has indicated that a credit rating downgrade could result from the ratio remaining below 25% on a sustained basis. Moody's calculation of Duke Energy Progress' FFO to debt ratio was 19.6% in 2018 and 22.4% in 2019, and has indicated that a credit rating downgrade could result from the ratio remaining below 20% on a sustained basis. Of equal importance are the qualitative factors that the credit rating agencies assess when evaluating the company's ratings. The most important qualitative factors are the regulatory framework and the ability to recover costs and earn fair returns. The agencies want to be confident that the companies operate in a stable, supportive regulatory environment with consistent and predictable regulation that allows the companies to recover prudently incurred costs and earn a reasonable return on investments. The agencies currently view the company's regulatory environment as a generally constructive one that supports long-term credit quality. But this assessment is predicated upon their view that this jurisdiction allows recovery of prudently incurred costs and reasonable returns, as exemplified by its treatment of coal ash compliance costs in the company's last rate cases. However, the agencies may well be reassessing their views. The most recent Moody's credit opinions issued with respect to the companies emphasize Moody's ratings outlook reflects its expectation of full recovery of the majority of coal ash closure costs. In Moody's Duke Energy Progress credit opinion issued March 30th, 2020, and Moody's Duke Energy Corporation credit opinion issued May 5th, 2020, both of which postdate the Commission's order in the recently concluded Dominion, North Carolina rate case. Moody's explicitly reiterates the agency's expectation of a full return on those costs. The credit opinions further specifically indicate that a factor that could lead to a downgrade in the company's credit ratings is a decline in credit supportive regulatory environments, particularly with respect to coal ash compliance cost recovery. In sum, it is clear from their own pronouncements, the rating agencies are closely watching the outcome of these cases. A downgrade, should it occur, would be detrimental to the interests of the company's customers, as it would raise the cost of capital and lower the company's ability to access capital on the terms it enjoys today, and perhaps any terms in highly volatile and unstable capital market conditions. That result is not in the best interest of the companies or its customers.
Chair Mitchell, the panel is now available for cross-examination.
All right, thank you, Mr. Mehta. Mr. Grantmeyer, you're up.
Good afternoon, gentlemen. My name is Bill Grantmeyer, Public Staff Attorney, and all my questions will be directed to Mr. Newland. Mr. DeSantis, I apologize. Can't have any fun today. Thank you.
One of these days I'll be back. I'm sure we'll have fun.
Mr. Newland, first we're going to do direct. Now, you've introduced your both direct and rebuttal. Is that correct?
Ask that again.
We're cross-examining on both direct and then rebuttal this time, correct?
That's correct.
Okay. Now, on the Duke Energy Carolinas direct testimony, I refer you to page 5 towards the bottom of the page.
All right.
In that, you're talking about your specific financial objectives. Now, A was at 53% common equity, but you settled for 52%. So I'm assuming, is it correct that you're satisfied with a 52% approved common equity?
Well, in the settlement agreement with the public staff and several other interveners, we've agreed on a number of different points. I think the point of a settlement is there's compromise on all sides. And so as the company has decided on that particular piece in terms of capital structure, I am satisfied.
And you also settled for a 9.6 ROE, is that correct?
That's correct.
And you were satisfied with that as far as the settlement, or else you would not have settled. Is that correct?
Well, that's correct. There's a lot of things I would point out that go into a settlement, a lot of compromise on all sides, and a number of different issues. And there's some things that we gave on, and there's some things that are positive for us in terms of credit quality, and it's all in a package, but those figures are correct.
And also, you list item C, maintaining sufficient cash flow, and you settle with the public staff anyway on the grid deferrals in the neighborhood of $1.2 to $1.3 billion. Is that correct?
That's correct.
And won't that significantly help your cash flows?
The ability to defer and seek a return on it is a credit positive event that we settled with. I would point out as well that, within the settlement, there were a number of terms proposed from the public staff at the time that were not as credit supportive as the things that were decided in the settlement. So as the words eventually were written, settlement was an agreement and a compromise between all parties to come to the final agreement.
Now, I turn you to page 9 of this direct testimony.
All right.
Towards the bottom, you have that chart for the listing of the credit ratings.
Yes.
And for Duke Energy Carolinas, the Moody's issuer rating is A1. Isn't that correct?
That's correct.
Isn't that an extremely high rating for operating electric companies?
I wouldn't say it's extremely high. It's representative of strong credit quality. And there are other companies in the marketplace that carry a similar rating.
Well, isn't it true that there's only one NSTAR is the only other one with an A1 rating?
I would have to check, but I believe Alabama Power is an A1 rated credit. And I believe there are others. I don't have a full listing in front of me.
And for senior secured AA2 for Moody's, isn't that a very high rating for an operating electric utility?
Yeah, again, I wouldn't call it very high. I would call it a strong credit rating that benefits customers and employees by enabling us to issue debt on a competitive basis.
Well, can you name one operating electric company that has a higher rating, senior secured, than AA2?
Higher than AA2? I do not know. I'd have to research that to find one that was higher.
And for Duke Progress, their senior secured is AA3. Isn't that also a very high rating? It's only one grade down from AA2, correct?
It's only one grade down on a secured basis from AA2, so it's a little weaker than DEC. Again, I would call that strong. I wouldn't call it very high.
Now, what is, in the stipulation, what was the embedded cost of debt for DEC that, for Duke Carolinas that you agreed to?
I believe the weighted average cost of debt on DEC was 4.51, subject to check.
And what was Duke Progress?
I believe it's 4.11, subject to check.
Now, that's, I believe, 40 basis points lower than Duke Carolinas. Would that be correct?
That's correct.
So even though it has a lower first mortgage credit rating, it has a 40 basis point lower embedded cost of debt, correct?
Currently on the weighted basis, that's correct.
So you would agree that timing of obtaining debt factors in just as much as the credit rating for the company?
Well, the reason that the weighted average cost of debt is different on the two companies is essentially because of the timing and the maturity of the portfolio. As the debt rolls off, the higher coupon rolls off and is replaced by lower coupon debt, it's going to have a different weighting. So over time, as issues are mature and are reissued or refinanced, that rate will come down as interest rates decline, which has been occurring over time. And currently, that's what the math works out to be on the weighted average debt cost currently.
Now, if we could turn to page 10 of Duke Carolinas direct.
All right.
And towards the bottom on line 18, you discuss the negative outlook for Duke Energy Carolinas, correct? I'm sorry, for Duke Energy Corporation.
At the time, that's correct. That was correct. That's true.
And you mentioned 2018 storm damage. Now, what securitization once you issue your securitization bonds, enable you to recover that storm money in an expedited manner?
The agencies view the securitization as really a neutral type event. So S&P doesn't, S&P, for example, essentially ignores the debt and the surcharge that the company institutes in recovering that amount.
But you will recover the money as soon as you issue the securitization bonds, correct?
That's correct.
And Duke went to the legislature to get that legislation passed, and therefore you would not have done so if you did not think it was beneficial to do. Would that be a
Well, I think we also believe it's good for customers as well, because it typically the securitized debt is AAA rated, and so carries a very low coupon cost to customers. So it's beneficial, we think, for everyone, for the company as well as for customers in terms of recouping that cost.
Now, you also mentioned on line 21 that the regulatory lag was a factor in the negative outlook. Doesn't the grid deferral, if the commission approves the stipulation between the public staff and Duke, help significantly on regulatory lag?
Well, it gives, I think, a couple of things. It gives the ability to show that we have the impetus in which to make investments in the system, defer them on the balance sheet, and seek future recovery for them. It also shows, I think, the agencies a positive relationship with the commission, that being the concept of being able to make investments, have them deemed prudent for the investment, and then recovery on them in the future. So I think there's in many things, there's a quantitative and qualitative aspect to it that the agencies like to see.
Now, you also on line 22 mentioned the delays 21-22, the Atlantic Coast Pipeline. Surely you're not saying that in any way the customers are responsible for the Atlantic Coast Pipeline delays, are you?
No, I mean, this was the corporate level holding company credit analysis by S&P, and they were looking at the delay of cash flow from it coming online. And they're also thinking about the capital expenditures in the interim before it went in service, which of course now is a moot point.
Now, if we could go to your direct testimony on Duke progress.
Hold on. All right, I'm there.
And I go to page 26, line 4. You talk about equity funding from Duke Energy would be some of the capital provided to Duke Progress on line 4. Isn't that your statement?
Sorry, what page are you on?
I'm sorry, page 26.
Of the direct at DEP?
Yes.
Okay. I'm there. Okay.
And won't you agree that that statement is incorrect, because on your E1 item 38 that you filed, there are no planned equity infusions into Duke Energy Progress by Duke Energy on that schedule covering about 6 or 7 years?
Well, the statement that it's funded from internal cash generation is certainly true by a function of a certain amount of retained earnings. The issuance of debt will be true at DEP. Then equity funding from Duke Energy, there's always the potential for Duke Energy to have to do capital infusions, which they haven't had to do, as you point out, in quite a while, but the option is there. And then the equity funding from Duke Energy also supports the commercial paper program and the money pool program. So good quality of the holding company supports all the purposes of the subsidiaries.
And you all would also agree that the E1 filed on behalf of Duke Carolinas did not show any equity funding from Duke Energy during that period. Is that correct?
We did not have any equity injections from the parent down to the subsidiary. That's correct.
Now, if we could turn to your rebuttal testimony filed for Duke Carolinas.
All right.
Now, you say on the bottom of page 3, you talk about the need for consistency in commission decisions. Now, the public staff's position, would you agree, is not contrary to the commission's February 2020 Dominion Energy Order in regard to no deferral on coal ash costs and a length of time greater than 5 years proposed by Duke? Would you agree with that?
You ask that question again.
You talk about consistency that the rating agencies look for in commission decisions, but you would agree, would you not, that the public staff's position of deferral or extended time to recover coal ash costs with no return on the deferral period is consistent with the commission's Dominion Energy decision in February, whereby return on coal ash was denied and length of time was greater than the 5 years recommended by the company?
That decision, if applied to DEC and DEP, would be inconsistent with our prior rate case. I would also point out that I believe the decision made in the Dominion rate case is different than what was allowed or permitted in DEC and DEP's rate case in 2018, so it was not consistent.
Excuse me, I'm moving forward in skipping a lot of your. Now, if we could go to page 14 of this rebuttal testimony.
Yes.
This lists the dividend payments by Duke Carolinas up to Duke Energy Corporation. Is that correct?
That's correct. Historically, yes.
And in 2016, it was much, much greater. Was that the year of the Piedmont merger or Piedmont acquisition?
It was the same year, but it was not related to that.
Okay. Chair Mitchell, I would ask that this cross-examination exhibit be identified as public staff number 27.
All right, Mr. Grant, I just want to make sure I'm following here. You're asking us to refer to the document that's been provided as public staff number 27?
Yes.
Okay, how would you like to mark the document, Mr. Grantmeyer?
It'd be public staff rebuttal, Newland cross-examination exhibit, sub 1214 and sub 1219. The public staff exhibit 1.
Okay, why don't, so I just want to make sure I've heard you correctly. Would that be public staff, Newland, rebuttal, cross-examination?
Yes.
Public staff cross-examination exhibit number 1?
Yes.
Okay, the document will be still marked for identification.
Do you have the docket, Mr. Newland?
I have the document, yes.
Now, you recognize these numbers, and we have it footnoted that it comes from your testimony as far as what has been paid from 2015 to 2019. You agree the numbers are correct?
Yes.
And then the 2020 through 2023 are the numbers from your E1 that was filed for each company?
Yes, that's correct.
Now, you would agree that the year 2016 of $2 million or $2 billion, $2 billion would be an outlier, would you not?
Yes, it was. Yes, it was an outlier. I believe it was done to essentially reset the capital structure in that year.
So, in down towards the middle of the page, we list the average 4-year average of dividends paid for Duke Carolinas, and it was $513 million. Would you agree to that, excluding the $2 billion year 2016?
I haven't done the math to do the average, but I'll accept that as the average, excluding the one outlier. Yes.
So the projected going forward for the 4 years, 2020 going forward, is $1,013,000,000. Would you agree with that?
Again, I didn't run the math to check the average, but I would agree to that. That seems reasonable.
And would you agree that the going forward, the difference between the two is a 97% increase of the average annual dividends paid to Duke Energy Corporation?
Again, I haven't done the math on that, but I mean, that percentage calculation seems correct.
Now, going down the page, we talk about Duke progress, and I will point out the second line there says Duke DP 5-year average, 2020 to 2023. That needs to be corrected to a 4-year average because there's only 4 years there. But you would agree that the 5-year average of actual dividends paid up to Duke Energy Corporation for 2015 to through 2019 averages out to $120 million.
Again, I didn't check the average on your math, but I will agree that seems to be correct calculation.
And the going forward 4-year average comes out to be $706 million.
The same. I didn't check the math.
Sorry,
But
but
that should be the average.
Mr. Grantmeyer, could you repeat that number, please?
Would you agree that the 4-year average 2020 to 2023 comes out to be $706 million?
And subject to check, that math seems right.
And would you agree with the math that that's an increase of approximately 533% over the previous 5-year average?
That would appear to be the math.
Now, when you were doing these projections of dividends going up to Duke Energy Corporation, at that time, the Atlantic Coast Pipeline was still in progress, wasn't it?
That's correct. These payments had nothing to do with Atlantic Coast Pipeline.
Well, infusing the equity up puts equity into and cash to Duke Energy Corporation, doesn't it?
It does, but there's a lot of uses for that. I mean, over the previous 5 years, as you see there, if you think about the dividends going up to the holding company as a percentage of net income, so like a dividend payout ratio, it's been 50% or less in terms of what's been going up to the holding company. And some years it's zero at Duke Energy Progress, again, to fund the capital expenditures that occur down at the operating level company. And going forward on the projections, while the percentage contribution is higher in terms of the dividend payout ratio, if you look at the contribution from both of those operating companies up to the holding company in terms of a dividend payout ratio, so the dividend as a percentage of net income, it averages over a 20-year period between 40 and 60%. So it's a very, I would call a reasonable percentage that is skewed over time. Some years is lower, some years is higher. It's below, for example, what the dividend payout ratio is of the holding company. So we endeavor to as we can to fund operations as possible, as well as to maintain the equity debt mix that's deemed appropriate by the commission.
Now, I turn you to page 23 of the rebuttal testimony.
Which company?
Same one, New Carolinas.
Okay.
Yeah, I'll let you know when we switch to progress.
Okay.
And you see about, you talk about you don't want to rely excessively on third-party capital. Isn't that what you say on page line 9?
Yes, I say that.
And isn't it now, Progress Energy, Progress issued $700 million in bonds on August 20th, correct?
DEP?
Yes.
Yes.
And what was the rate for the 10-year?
I believe DEP did a 30-year security.
So it was only a 30-year security?
You're talking about DEP, not DEC?
Yes. Yes, on August 20th.
Yeah, it was the 30-year security, 2.50% was the coupon on that.
Now, isn't that an extremely low interest rate for a 30-year bond?
In terms of spread over treasuries, it's comparable to what the company has enjoyed previously, about 115 basis points or so over the comparable treasury. Treasury rates have come down, I think, as everyone knows, with the recent pandemic crisis. And so the all-in coupon rate is low. In fact, it's the lowest coupon in the Duke complex right now. But in terms of a relative basis, in terms of spread to treasuries, it's the way we kind of think about, the credit quality impacts. It's about where it has been.
Now, does that complete New Progress's bond issuances for 2020?
Yes, it does. We also did a floating rate instrument at the time, and so that should complete their funding for 2020.
Now, back in January, Duke Carolinas issued, wasn't it $900 million in debt? Remember the exact amount?
That sounds familiar. That sounds right.
Now, we'll get to the exact amount later on, but did that complete Duke Energy's or Duke Carolina's debt issuances for the year 2020?
I believe it did. For DEC, we were early this year and issued. Yeah, I believe that completed the required funding for it. Yeah.
Now, towards the bottom of the page, in several places in your testimony, rebuttal testimony, you talk about, they look at credit opinions as to potential defaults. Surely you're not saying that there's a potential for default of Duke Carolinas or Duke Progress, do you?
You're talking about line 20 of the DEC?
I'm sorry, line 18, potential default.
Right. So the Moody's rating, whenever a rating agency applies a rating, it does take into account within its letter ratings the default risk. So, I mean, a AA or single A credit would have a much lower default risk than, say, a double B type credit.
Now, if we could turn to page 25, line 7
Okay.
to 9, where you're
Sorry, what line?
discussing Do you have it?
Page 25, what line are you referring to?
7 through 9.
Okay.
Now, Duke is in the. Have you issued the stock for the 2.5 billion? I understand it's going to be by the end of the year. Is that correct?
Well, we have sold the stock, and we've sold it into a mechanism in a forward settlement, and we intend to settle that forward contract in December.
So you would receive, that would increase Duke Energy Corporation's equity by 2.5 billion. Is that correct?
That's correct.
And it would also give you 2.5 billion in cash. Isn't that correct?
Less the dividends paid over the year, less the carrying cost from the bank doing the forward contract, but in general, that's right.
The issuance cost, basically.
Yeah, that's right. There's a cost to carry for them holding it for a year. But I would remind you that, you know, the holding company took a $2 billion write-off in writing off the Atlantic Coast Pipeline pre-tax, and this was issued with the intent of replacing that should that event occur. The equity again.
But part of Duke Energy Corporation's credit ratings significantly lower than both Duke Energy Carolinas and Duke Progress is its much lower equity ratio than the other two operating companies. Isn't that correct?
It is a combination of, it's a little more levered at the holding company and it's further from the assets. So whenever a rating agency typically looks at a holding company that's kind of one step removed from the physical assets, they will tend to lower the rating or notch them as they typically do.
And isn't the FFO to debt for Duke Energy Corporation in the range around 14%?
About 15%, but yes.
So that would be much lower than both Duke Carolinas and Duke Progress.
That's correct. That's correct, and the ratings reflect that.
Now, on page 26, the last full paragraph, just on line 15, said Moody's looks at FFO to debt on a sustained basis, and sustained basis is not defined, is it?
I don't believe so.
And also, they use a 3-year basis in their reporting, similar to what Mr. Hinton did. Is that correct?
They do, yes.
Now, you talk about a downgrade, if there's a downgrade going down one grade. Now, if Duke Carolinas right now is AA2, so there would be a downgrade. If it was downgraded, it would be to AA3. Is that correct?
That's correct.
But you talk about to get back up, they would have to get to AA1. That's on line 17 would require 30% FFO to debt level. And if they're only starting at AA2, why would we discuss getting to AA1 to get back to the previous debt, credit rating?
Yeah, so in that, when I write that, at the beginning of that sentence, I say, for example, as an order of magnitude, an upgrade to AA1 would require a 30% FFO to debt level. That would be a full 5 percentage points increase to go up a notch. And the further point within that is rating agencies don't like to lose rapidly or go down and go up. If a company gets downgraded, they tend to stay down for a while, even if the metrics improve in the short term, because they want to see that the company's able to maintain a higher metric, whatever that metric is. Here we're talking about FFO to debt for a sustained period, 3 to 5 years, I think is a fair amount. So the point of the commentary was to say, if you get downgraded, it's difficult to get up there. You got to show good metrics for a sustained period to claw your way back.
Yeah, but to get back to the AA2 would only require DEC to have approximately a 25%, not a 30% that you list there.
Well, again, it's for an order of magnitude to show a full 5%. So the AA3 is a 20%. So it's 20, 25, and 30. And in my opinion, if we were downgraded, DEC was downgraded to a AA3, if they just came back up to 25, I don't think they'd be upgraded. The agencies who want to see a cushion, they'd probably want to see a, I don't know, 26 or a little north of that before they did an upgrade.
But it certainly wouldn't be required to get up to 30% like you list there, would it?
No, again, that was to show, maybe it wasn't clear, it was to show an order of magnitude. To go a full ratings notch up, it's 5% on a sustained basis, which is quite a difference in terms of cash flow.
Now, if we could turn to page 30 of this rebuttal testimony.
All right, Mr. Grantmeyer, I'm going to stop you right there before you get into this next line of questions. We're going to take a 15-minute break. So everyone, please turn off your video and mute your line, and we will go back on the record at 3:45. All right, let's go back on the record, please. Mr. Grantmeyer, you may continue. Mr. Grantmeyer, you're on mute.
Mr. Newland, in your rebuttal testimony, you talked about how the credit agencies, or rating agencies, like to see riders. Is that correct?
That's correct. They see that as credit positive.
Now, would you agree? I'm going to read a list of Duke Carolina's riders in North Carolina, and would you agree? Tell me if you agree with this. Annual fuel cost adjustment rider, annual renewable energy adjustment rider, annual demand side management and energy efficiency rider, and annual competitive procurement of renewable energy rider. Would you agree that those 4 riders are in effect for Duke Carolinas?
I mean, those riders are for fuel costs and for, I think, somewhat smaller capital programs throughout the system.
Well, it's also what is frequently referred to as REPS. Is that correct?
I'm not familiar with that term.
Okay. And would you agree that Duke Progress has those same 4 riders, but also has 1 additional rider, annual joint agency asset rider?
Yeah, I'm familiar with the fuel riders. I'm not familiar with all those other riders. Witness to May, I'm sure, is much more familiar with those.
Now, moving back to page 30 of the rebuttal testimony for Duke Carolinas, I refer you to the top of the page where we talk about the October 31, 2019 credit opinion.
Okay.
And they cited the strengths of Duke Energy Carolinas credit supportive regulatory environment. Would you agree with that?
I believe that's what they cited, yes.
And you agree that a growing service territory is important in their credit ratings, isn't it?
It is, as is the composition of the customers. So they talk about diversity in some of their ratings reports. So it's not just the territory, but also the makeup within that territory.
But Duke's territory is growing customer base, isn't that correct?
It is.
And also, they point out the utility's position as part of the Duke Energy utility system, that the entire Duke system has strengths to it.
Yes, I see. They're speaking about the portfolio effect. Yes.
And isn't it true that North Carolina is only second in growth to your Florida utility of the Duke Energy electric companies?
I believe that's correct. That would have to be researched and checked, but I believe that's correct.
Now, you talk about, in the middle of the page, you talk about FFO to debt, but under the Moody's credit rating system, that's only 15% of their total credit rating. Isn't that correct?
Well, the agency's, Moody's on its ratings grid in particular, looks at qualitative and quantitative aspects. Within the quantitative aspects, which is roughly 50%, FFO to debt is a component within that. But if FFO to debt were impacted, there's a number of other FFO metrics within that same ratings grid that would also be impacted.
But there's a total of 100%, and this is only 15%, correct?
For that one metric, FFO to debt, they look at many other metrics as well as qualitative metrics, but yes.
Chair Mitchell, we would ask that this next cross-examination exhibit be identified, and it is public staff number 23. And once everyone gets it, I'll try to give you an identification.
Okay, Mr. Grantmeyer, would you please give us the page number down at the bottom of the page?
I'm sorry, 303.
All right, let's go ahead and get it marked for identification.
We request that this be marked as Public Staff Newland Rebuttal Cross-Examination Exhibit Number 2.
The document will be so marked.
And do you recognize this as a response to data request 166-4 sent to Duke Progress?
I do.
Do you recognize it as that?
Yes, I do recognize it.
Now, on the next page, 304, the second page, you see that it was prepared by the Treasury Director.
Yes.
And so you assume that your Treasury Director prepared it, it's correct.
Yes, I do.
Could you please read the response, the highlighted part that begins with "in a relatively normal"?
The entire paragraph?
Yes, please.
Okay. In a relatively normal or typical period in the bond market, an A2 issuer rating, AA3 senior secured utility rating, utilities similar to DE Progress would be expected to price up to 10 basis points wider as an A3 issuer rating or A1 senior secured rating utility. Please note that the pricing of bonds at different credit ratings can be impacted by a variety of factors, including unique supply and demand factors the day of issuance. Additionally, greater differences can be expected during periods of dramatic market volatility, where investors have more uncertainty on the credit quality and ability for issuers to potentially meet future commitments.
Chair Mitchell, we would move public staff cross-examination exhibit number 25, which is page 307. It's a one-page exhibit.
All right, Mr. Grantmeyer, let's mark it for identification, please.
Public Staff Newland Rebuttal Cross-Examination Exhibit number 3.
All right, it will be so marked.
And do you recognize this in the top right-hand corner? It's your E1 item 23, 33D, and 38.
Yes.
And the title says Duke Energy Carolinas, but that appears to be a typo because this is 1219, so it's really Progress we're talking about.
I agree.
Okay. Now, line 4 shows your debt retirements for the period 2019 to 2023. Is that correct?
Yes.
And would you accept for the years 2020 through 2022, the 3 years, the total debt retirements are $2.1 billion?
I would.
And going down to line 12, outside financing, that's where you're obtaining, I'm sorry, line 14, outside long-term debt. That's the issuance of your long-term debt, correct?
Yes, estimated in that projected time period, yes.
And for the projected time period of 2020 through 2022, the estimated amount for those 3 years totals $2.75 billion. Would you agree with that?
Yes.
Now, going down the page, line 23 has the common stock ratio and long-term debt ratio for those 5 years. Is that correct?
Yes.
And you would agree that each of the 5 years has 52% is what you filed with your application in the E1. Is that correct?
That's correct.
So the 52% that you agreed to in the stipulation corresponds with what is in this E1 filing, correct?
Well, this was the projection that was made in the E1, and it shows 52%. I guess I'm not privy to exactly what all the discussions were inside the settlement.
Now, as we said, the 2020, that 900,000 has already been issued. So regardless of what Moody's may do in the future, that would not be affected because you've already got the loans, correct?
Well, I mean, this was prepared at a point in time where 2020 was a projection. And so today, as we sit here on August 24th, some things in this projection have come true, some probably have not come true. The 900 million, as you stated, was something that we have done. But there's many other projections on here that, you know, may or may not be complete as of today.
But anyway, you're done with your bond issuances for both Duke Carolinas and Duke Progress for the year 2020. Isn't that your testimony?
Yes, short of a hurricane or something like that that we need to pay for, something unexpected. Yes.
Now, if you were to Progress, it was a 10% increase, and we'll get to Duke Carolinas later. But this 900 million that we're talking about for 2021, we increased that by 10 basis points. That would be about a $900,000 a year increase in interest costs. Is that correct?
At 900 million times 10 basis points?
Yes.
Yes, I believe that's correct.
And, but if you're borrowing money at 2.5% like you just issued, even with a 10 basis point increase, you're still only going to be at 2.60%. Would that also be one of the lowest you've ever had in the Duke system?
I guess I would refer back to my answer on Public Staff 23 when I gave the 10 basis points differential. I characterize that by being a relatively normal or typical period in the bond market. There are times like we experienced during COVID-19 where it's not a typical period in the bond market and we need to access capital, and it may come at a much higher cost than what we see in a rather sanguine period.
But right now we're in a fairly typical bond market except that the Fed is exceptionally low on its rates.
Agreed. Things have settled down a bit for just now.
Madam Chair, we would like now to move to public staff number 24, cross-exam number 24, which is page 305.
All right, let's mark it.
And we ask that this be identified as public staff Newland rebuttal cross-examination exhibit number 4.
All right, it'll be so marked.
And you would agree that this is a Duke Carolinas data request response item 230-6?
Yes.
And could you please read what the request was?
Sure. Number 6. Given the recently issued $900 million bond offering and the company's E1, item 38 indicating that approximately $1.5 billion of external debt capital will be needed through 2023. Please provide an annual estimate of the additional financing costs associated with a 5 basis point increase in period of low interest rate and tight credit spreads to DEC's embedded cost of debt capital from 2021 through 2023.
Now, isn't it true that Duke Carolinas gave the public staff that 5 basis point increase? That's what they projected it would be?
I'm sorry, who did you say gave that estimate?
Duke Carolinas said it would be 5 basis points for Duke Energy Carolinas.
Yes.
And one reason between the 5 and 10% or 5 and 10 basis points is that Duke Carolinas has a higher rating.
That's correct.
And could you read the response, please?
Yep, response. Based on the size of forecasted new debt issuances relative to the company's approximately $11 billion bond portfolio, the relatively low cost of debt in the current market, and the ongoing retirement and the refinancing of maturing higher cost debt over the forecast period, the overall embedded cost of debt is expected to increase by up to 1 basis point under the scenarios requested. See a related attachment PS DR 230-6 and 7- estimate of the cost of debt for the related analysis requested.
Now, if we could turn to the next page, which is page 306, and I hope everyone could read it because the print is fairly small. Do you recognize this as part of Duke Carolina's response?
I do recognize it.
And it shows in the middle of the page the 2020 January issuance by Duke Carolinas. Is that correct?
Hold on. Yes.
And it shows $500 million of 10-year at 2.45% coupon.
Yes, it shows that.
And 30-year, $400 million at 3.2.
Yes.
And so that is 70 basis points higher than Duke Progress just got on August 20th, isn't it?
For the 30-year, that's correct. I mean, it's a different point in time. It's January versus August. That's correct.
But in that this is such low interest rates, wouldn't it be beneficial to Duke and its customers to issue more bonds at this extremely low interest rate, particularly long-term, like 30 years?
Well, not necessarily. I mean, if we issue so much debt that we become overly indebted, it would impact the credit ratings of the company and therefore would have a higher risk of default and ultimately lead to a higher cost of capital for customers.
But didn't we establish earlier that there's virtually no risk of default by Duke Carolinas or Duke Progress?
Well, if you're at the current ratings of AA2 or AA3, that's correct. But if you just wantonly issue debt to get a hold of a low coupon, you would increase the amount of debt on the balance sheet, and therefore the increase of default would go up.
But as we look over 5 basis in the composite of the two, the weighted average was 2.78%.
Right.
You see that?
I do.
And when you add the 5 basis points to it, their potential downgrade, it comes out to 2.83% if you move a little bit to the right. You agree with that?
In this example, yes.
And if we add the 10 basis points further to the right, it comes out to 2.88%.
Correct.
Now, wouldn't that also be an extremely low interest rate?
I'd say it's competitive for the rating at which the company is ranked.
Now, towards the bottom of the page, it shows to the bottom left, it shows your debt retirements. Is that correct?
It does for those 3 years.
Yes. And in it, it shows as we move to the middle at the bottom, doesn't it show the estimated cost impact of the issuance of new debt versus retirement debt?
Yes, to refinance that maturing debt, that's correct.
But at the bottom, in the middle, it has only 1 basis point difference. Isn't that correct?
It does. Again, this is a 3-year period, which doesn't take into account the entire bond portfolio. The entire bond portfolio won't mature in 3 years. And this analysis was taking into account just the 3 years of maturity.
And if we move further to the right at the bottom, it shows even with a 10 basis points, that would be applicable to Duke Progress, it's still only a 1 basis point increase.
That's correct.
Chair Mitchell, we'd like to bring up Public Staff 26, and the page at the bottom is 308.
All right, how would you like to mark the document?
Public Staff Newland, rebuttal, cross-examination, Exhibit 5. Do you have it, Mr. Newland?
I do, yes.
All right, the document will be so marked.
You recognize this as the E1 filed with your application, item 33D, which is also 38, is the same exhibit.
Yes, I recognize it.
And you see in the issuance of new debt down on line 14, the total for the 3 years, 2020 through 2023, is 2.1 billion. Is that correct?
Line 14, is that the one you're looking at?
Yes, that's the new debt issuance.
2.4, is that the number you came up with?
I'm sorry, I came up with 2.1, but that's lawyer's math. Yeah, I trust you better.
All right, so I'm trying to do it in my head. Just I can calculate it. So you're doing 2020 through 2023?
22.
Oh, I'm sorry, 22. Okay.
That's
my mistake.
That's the differential there, the 300 million.
2.1 billion, yes.
Okay. And we've already taken care of, as you testified, 2020. So what we have left then is 221 and 222 is 450 plus 750, and my math comes out to 1.2 billion. Would you agree with that?
Yes. Barring any unforeseen events that we'd have to fund, such as hurricanes, et cetera.
Now, for 2021 at 450 million times increased by 5 basis points, a downgrade would only add $225,000 a year in interest costs to what would otherwise be the interest rate. Doesn't that math work?
Well, yes. I mean, again, if the 5 basis point differential holds, and it'd be for just that one issuance, but yes.
And again, 5 basis point added to the 750 million is only $375,000 per year. Is that correct?
Subject to check, but I think that's right. Yeah.
Now, one of the issues that you talk about in your rebuttal testimony is the coal ash different positions between Duke and the public staff. Isn't that correct?
All right, Mr. Newland, I'm gonna stop you right there. Mr. Grantmeyer, would you please? Our court reporter is having a hard time hearing you. So will you make sure that you're speaking into your microphone and looking into the camera so that she can see your face?
Is this better?
She's giving me the thumbs up, so it must be better. Thank you.
Okay.
Sorry, that wasn't a thumbs up. If you, Mr. Grantmeyer, if you could just raise your head a little bit, your mouth is being covered by your name on the screen.
Okay.
To your left.
I keep getting coached on that. I better do better.
You're doing great. Thank you.
Has Duke done a comparison of the revenue requirement effect of Duke's position versus the public staff's position on coal ash?
I'm not certain.
Well, if Duke hasn't done one, how do they know that they're going to be damaged by the public staff's calculations?
If there's if we're not allowed the recovery on the expenditures for coal ash, given the size of those expenditures, it would be detrimental from the quantitative aspects of the FFO to debt metric, as well as in the qualitative aspect that the agencies talk about in terms of consistency regulation.
But in your testimony, you talk about better credit ratings benefit the customers, don't you?
Yes.
Now, the public staff position is much different from y'all's. It's a 27-year recovery, isn't that correct?
I'm not certain as to the staff's proposal on the years of recovery.
And it would be without any return during that period.
I believe that's correct.
And the company's is 5 years with a return.
Of and on, that's correct.
Well, would you accept, subject to check, that the differential in revenue requirement between the two, the first year for Duke Energy Carolinas would be $86 million. The public staff's recommendation would be $86 million less than Duke Carolinas.
I'm sorry, ask that again. What are we willing to?
The public staff's recommendation would result in a revenue requirement $86 million less to the customers than Duke's request.
All right. I'll accept that for our discussion, sure.
So since $86 million would be the revenue requirement reduction, and we looked at the $900,000 increase in the interest rate for a possible downgrade, aren't the customers much better off with the public staff's recommendation than Duke's?
Well, perhaps not, because if the agencies move to do a downgrade because of the treatment of coal ash, then that differential that you're talking about in terms of the funding on the future debt will no longer be that 5 or 10 basis point differential. It could be different, and it will continue over a much longer time frame. So the issues are interrelated, depending on how the agencies wind up rating it.
But with the extremely low debt costs now, even if it went up 20 basis points, that would still, on $900 million, that would only be $1.8 million increase, offset against $86 million savings to the cut revenue requirement.
Well, as I talk about in my testimony, when there are periods of dislocation in the credit markets, that amount could be much greater. It could be 5 basis points, 10 basis points. We saw during the COVID pandemic where it expanded out to 78, 80, 90 basis points. So it can definitely vary depending on the market in which you are trying to borrow.
Now, Duke Energy Corporation has a revolving credit agreement with a lending institution. I believe it's $8 billion. Is that correct?
That's correct.
And what is Duke Carolina's allocation, or what's their total that they could draw down on that?
It varies. It varies. I mean, depending on the capital needs of the company, we set sublimits within the different operating companies. I don't know exactly what that sublimit is today, but Duke Energy Carolinas is one of the larger companies, obviously, and it has one of the larger sublimits within the $8 billion facility.
And do you happen to know by chance what they're available that they could draw down now that is still outstanding?
I don't have that in front of me, and we do routinely look at that to make sure that the sublimits are appropriate for all of our utilities across the family. But I don't know that exact amount right now that they have.
And Duke Progress would also have a large allocation that they could draw down.
That's correct.
So if in fact they needed to borrow money during a COVID, they could access that. Instead of dealing in a COVID environment, they could access that temporary money.
Well, that temporary money also will float, based on the availability of credit. So at the holding company, we typically borrow money in the commercial paper markets without tapping into the line of credit The reason for that is because commercial paper as a funding vehicle is usually more affordable than your line of credit. And the commercial paper markets, you've seen the activity by the Fed during the COVID crisis. The commercial paper markets, especially for an A2, P2 issuer like Duke Energy, widened greatly. And for some tenor of securities, it wasn't available. Overnight was available, but a lot of times a 30 to 40 day type of borrowing in commercial paper was not available during March. And so that market can be somewhat fickle. Now, within the credit facility from the banks, which we use as a backup for commercial paper, it's more expensive, but it'll be based on a draw based on a LIBOR or underlying floating rate of interest, and that amount also expanded greatly. So the cost of capital can be pretty expensive during times of dislocations. Really, the one reason that DEC and DEP have such availability for capital during times of dislocation like that is, again, because of their strong credit ratings. They are seen as a pretty safe borrower with those existing ratings.
But Duke Carolina's borrowed its money in January, long before COVID-19, correct?
Yes, but I was making the example you'd asked about during COVID. So I was talking about what the availability was during that time.
And the debt market is very good right now for borrowing, in that you got a 2.50 interest rate on $700 million. So the COVID is passed. As far as the shock in the financing market.
Well, it has for now.
And it only lasted about 2 months, the lending problems.
There are various dislocations in the market that last for varying periods of time.
Now, has Duke done a comparison of what the revenue requirement impact would be for Duke Progress, the public staff's coal ash treatment versus Duke Progress's?
I'm trying to remember, like, we have done referring back to your earlier question, we've done some analyses, taking a look at different treatments of the coal ash and what that does. Specifically, as I remembered, our FFO to debt metrics and the negative impact that it has to them, both at the holding company and at the operating companies.
But would you accept that the public staff has calculated the difference would be the first year, $100 million? If the commission adopts the public staff's recommended treatment, it would be $100 million revenue requirement reduction compared to Duke's request?
Subject to check. I mean, yes.
Good news is I ran out of exhibits, so we'll just have to move on. Now, Duke is issuing $2.5 billion in equity, and that is to get cash, but it's also to boost their balance sheet. Is that correct?
At the holding company, that's correct.
So if in fact the holding company decided to issue another $2.5 billion in 2021, that would bring in more cash and also strengthen their balance sheet, wouldn't it?
Depending on what the use of proceeds were, yes.
And how are the customers damaged by Duke issuing more equity and more stock to the market?
Well, for example, the $2.5 billion we did last November, which again, we should settle this December. When we issued that, it had a negative effect on the stock price. I'm going to use rough numbers here, but we had about a 7 to a 12% discount when we issued the stock out of the holding company, which was a fairly large discount. It was seen by us as a negative reaction to the company doing that. a decline in the stock price implies a higher equity cost of capital. And if that were to continue, or if we were to do that again unexpectedly in the public markets, I think eventually that'd be seen as a higher cost of equity capital, and that could negatively impact customers from that higher funding cost, again, driven by our external investors at the holding company.
But doesn't it really hurt the stockholders much, much more than the customers? What do the customers care about what the stock prices are?
Well, again, I think, eventually if the equity cost of capital is higher, then it's going to be more expensive for the holding company to fund, for example, the money pool and everything that goes with that. And so there could be trickle down effects from that higher cost of capital to customers within the operating companies.
Okay, we're going to move on to the Duke Progress rebuttal testimony. And we've covered a lot on Duke Carolinas. But if we could go to page 24.
All right.
And the last paragraph around lines 17 through 22, you're talking about Duke Energy Indiana's $550 million 30-year first mortgage, correct?
Correct.
And it was 2.75% issued on March 10, which is the very beginning of the pandemic.
Yes.
And that it isn't Duke Energy Indiana's credit rating is the same as Duke Energy Progress, isn't that correct?
Yeah, that's correct. And I think that's why we were able to get that deal done during the pandemic. That's right.
Now, one thing, when we add the interest, say you add 10 basis points, doesn't the company get a tax deduction on the interest paid?
Utilities do, that's correct.
And the combined interest rate for North Carolina State and federal is approximately 23%, isn't that correct?
I believe so, subject to check.
And isn't income tax figured in when the revenue requirement is designed or determined?
Yes, my understanding is it is.
So if it's 10 basis points going up in interest and 23% of that is deducted and reduces your income tax, really, it's not a 10 basis point increase. It's about a 7.7% increase, 10 basis points less 23%. Wouldn't that be correct?
I'm not really following your math there, but
if it's 10 basis points and 23% of that is tax deductible and comes off the income tax, then it would be less than 10 basis points.
Yes, yes.
Now, on page 25, you talk about the Entergy had to cancel on March 17th, St. Patrick's Day, correct?
Yes.
But their rating is Baa2, which is much, much weaker than Duke Progress. Isn't that true?
Well, right. I guess that's the point of my commentary, and that part of the testimony is to say that Duke Energy Indiana, because of its strong rating similar to DEP, was able to get a deal done, whereas a weaker rated credit such as Entergy Corp was unable to do so during the pandemic.
Now, Entergy Corp at Baa2 is really 5 grades lower on Moody's than Duke Progress's AA3. Would you agree to that?
Yes.
And Entergy Corporation, they have the Entergy New Orleans, isn't that correct?
They do own that subsidiary, yes.
And that went bankrupt after the hurricane a number of years ago, correct?
I believe so. I'm not certain of that, but I believe it did.
In that they totally lost a lot of their system in New Orleans, and for a sustained period, they lost their customer base.
All right.
Now, in regard to Appalachian Power, on line 11, their rating is BAA1. Is that correct?
Yes.
And would you agree that that's 4 grades lower than Duke Progress?
Yes, and they were unable to get a deal done as well.
Excuse me, I'm trying to get to the end here. One thing you talk about current markets, the debt markets is really at almost an all-time low now. Is that correct for long-term lending?
Yeah, I think the all-in coupon rates are, we kind of think about a spread to treasuries, which don't move as much. The underlying treasury comes down in yield. You apply the same spread. That causes the all-in coupon amounts to come down. But yes, I think you're seeing a number of corporates issue at kind of the lowest 30 years that they've seen during the last 30 years, certainly.
But you would agree that, at least for the stock market at this time, it's doing very well.
Yes, stocks in general have been up quite a bit since March, yes.
Would you agree that the S&P index hit an all-time high last Friday, August 21st?
I believe I did read that. Yes.
And also NASDAQ on Friday, August 21, reached an all-time high?
I believe that's correct from reading the newspaper, yeah.
Excuse me, this is Dylan. I just wanted to jump in on that. That doesn't dismiss the volatility that's been going on in the market or in the bond markets, by the way. There have been significant tumult in both the markets and the bond equity markets and bond markets. And the recovery in the market in general is driven by 7 companies. So if you looked at all the other companies that comprise the S&P 500, you'd see a lot more losers than winners.
Now, isn't Duke's, would you accept, subject to check, that as of Friday, August 21st, Dylan, this isn't your question.
I'm already muted.
I know. August 21st, that the Duke dividend yield was 4.77%.
Subject to check, yes.
And isn't it true that Duke's dividend yields have consistently been in the top 10% of all electric utility holding companies?
Well, I don't know about that, but our stock price has been down and hasn't been performing as well as some of the indices you mentioned, which would tend to make the yield high.
But there's only a couple of the holding companies that are higher than Duke's yield now. Isn't that correct?
I don't know.
Okay, thank you. I have no further questions.
Chair Mitchell, I think the Attorney General had indicated cross questions for this panel. I'm not sure if anybody else has indicated cross questions for this panel.
And that's what my notes indicate. I was just waiting for Ms. Force to move to her microphone. Ms. Force, you are up.
I think I've got my microphone on. Does that work do you hear me?
We can hear you.
Good.
All right, please proceed. Thank you.
Good afternoon, gentlemen. And happy birthday, Mr. Diasendis.
Good afternoon.
I may have we just
Thank you.
lost your
Yeah. I was trying to
video.
unmute to say thank you and good afternoon.
Okay, good. I'm going to have some questions that have more to do with rate of return on equity. Mr. Diasendis, I think I was going to say before you went off, your picture went off, that more of my questions are probably directed to you, but Mr. Newland, you may answer too if that works. And just for clarification, I think you've said some in your testimony. Mr. Diasendis, you have adopted the testimony that was originally filed by Mr. Hebert, is that right?
That's right.
So in other testimonies, it can be a little confusing in the long run. The transcript may refer to Mr. Hebert, but they would be referring to you at this point by substitution and your adoption, right?
That's right. Yeah.
Okay. Now, in your summary and in your settlement testimony for the second settlement that the public staff entered just recently, you agreed that it would be satisfactory under the terms of the settlement or sufficient for the company to have a rate of return on equity of 9.6% with a 52% capital structure. Is that correct?
Yes, and I said that in a fully litigated proceeding that I am confident that the rate of return is in between 10 and 11%, but given the give and take of the settlement and the settlement actually being done shows that the company is agreeable to a 9.6 ROE and a 52% equity ratio.
Okay. I apologize. I don't know how, if you're getting a ringing sound, that's my telephone and I don't know how to turn it off. So I've taken it off the hook and hopefully that will do the trick. That wasn't my cell phone. The settlement that was reached, though, that where the 9.6% ROE and 52% cap structure was agreed to, was not adopted by all the parties to the case. The Attorney General's office has not entered into that settlement, and so it's a non-unanimous settlement. Do you agree with that? And I think there's also the Carolina Utility Customers Association that has not agreed to it. They also had testimony in this case on the rate of return. Can you agree with that?
I agree to
As far as you know.
AG. I agree to AG. I don't know about CUCA. I thought they were early settlement people, but I'm not sure.
Well, it can be confusing. We have a lot of different alphabets, references to different organizations. We'll see. As I understood, Mr. O'Donnell was still going to be testifying, or at least giving a summary. We'll see what happens later on, perhaps tomorrow.
Okay.
In any event, it's not a unanimous settlement. And so ROE is an issue in the case, as well as the capital structure. The Attorney General's witness, Mr. Bodino, have you read his testimony?
I have.
And his recommendation is a little bit higher than, or excuse me, agrees to a little bit higher than some of the other economic witnesses, but lower than yours at 9.0% ROE and a 51.5% capital structure. Now, this is a big part of the case often. Would you agree with me that it's an often litigated issue, or at least one that's highly contested in the initial phases of the case?
I would say it's a lot like divorce. It's 50%. Usually half go litigated and half settle.
Okay. And there's a lot of expert testimony in the case in this case that addresses those issues. Is that right?
That's true.
So according to calculations that Mr. Bodino has made, because of the other costs in this case, the rate base, the impact on the revenue requirement for the difference between using 9.6 and 52% going instead by comparison to his 9.0 ROE with the slightly lower equity ratio would amount to 75.5 million more annually under the settlement than under his proposal. Do you have any reason to disagree with that?
No.
And that's in the Duke Carolinas case.
Okay.
In the Duke Progress case, the numbers are the same, are they not? The same equity ratio and ROE for the settlement, and also I'll submit to you that Mr. Baldino's numbers are the same, but when that is evaluated for how much it costs in the revenue requirement, the amount is 48.1 million annually. You have any reason to disagree with that?
No, I don't.
So the recommendation is not what you would recommend, as you've said, but it is supported by the testimony of 3 experts in this case, right?
That ultimately settled to 9.6. So, so then it's the same give and take that the companies made, where 2 out of the 3 parties have settled to 9.6. Even three out of 3. I mean, or 3 out of 4 if you count the companies and the 2 that recommended 9.0 and then Baldino. So 3 out of 4 settled at 9.6, whereas Mr. Baldino is the lone holdout.
Okay, I think, have you read Mr. O'Donnell's testimony in this case?
I have. I have.
And it's your position then, it's your understanding that his client has entered into a settlement in the case?
Yes.
Okay, we can check on that later. I'd submit to you that that's not my understanding, but we'll find out, I guess, when he testifies, if there's something that's agreed to. At the beginning of this hearing, when the settlements were listed, I did not hear that Carolina Utility Customers Association was among them. You may be getting confused with what's called SIGFR, which is another industrial group, and they had a witness who testified. He didn't actually do cost studies, but he did testify on economic. I think Mr. Phillips.
Okay.
Who you're thinking of? Anyway, getting back to the question about it, if you put those together, those amounts, those are all amounts for North Carolina retail customers that amounts to over $125 million a year that would be paid in utility.
Sorry, my lights went out.
Okay. You have power though, I guess.
Yes.
Okay. That's over $125 million a year difference in the cost of service for North Carolina customers across the state as a group. That would be money that's not available to North Carolina communities. Can you agree to that?
Sure, but that's, the cost of capital is a cost incurred by the utility companies. If they're agreed to a 9.60%, that's the cost of doing business, and it's not even a guaranteed number. The 9.6 is an opportunity to earn that number.
Okay.
So I think putting hard numbers in and the differences in this case and between the positions isn't all where you're these numbers aren't actually a guarantee. So these numbers, the numbers that you're talking about here aren't probably going to be realized in reality.
So at any rate, if the commission determines based on evidence in this case that was presented by at least some of the experts that the rate of return should be properly 9.0% as a sufficient amount for the shareholders' cost of equity, it would make that amount of difference the math works. Can you agree with me there?
That's right.
Even if you wouldn't agree with we can agree to disagree on the rate. In this case, just to put that in context, the Duke filed testimony, I think it was Friday, from Mr. Pirro, that the total amount that Duke would request under the second settlement for Duke Carolinas is $414 million per year before it adjusts that for the amount that goes back to customers in this tax rider that's part of it. You may not have those numbers in front of you, but when we look at that 75.5 million amount for rate of return, the differential, that's compared to Duke's overall request if it gets everything that it wants in the litigated issues with the public staff. That amount of 414 million would be reduced by at least that amount. The by comparison, in the Duke Progress case, you have 48.1 million we were talking about earlier as the difference using the settlement versus a lower rate of return. That compares to 409 million that Duke is seeking from its customers in the Duke Energy Progress case if its full request is granted otherwise. That amounts for residential customers to a 9.1% rate increase, even after the settlement, assuming that Duke gets its request. Do you have any reason to dispute that?
No, I don't.
And the overall increase would be 8.5% for all customers. For Duke Progress, the rate increase that Duke is still seeking before the tax rider would be 12%, or an overall, and that's from residential customers, or 10.9% overall.
Okay.
So there is a tax rider in this case, and that's actually the next issue in the case. That is amounts that, are you familiar with the tax rider issue and the proposal for how that would be money that goes back to customers?
I am not.
Okay, that's good. We don't need to go there. One of the considerations in the North Carolina statute for determining rate of return and rate of return on equity is the changing economic conditions that affect investors and customers. Would you agree with that?
Yes.
You've addressed some of that in your testimony, and so did Mr. Bodino and other witnesses in the case. The direct testimonies that were originally filed and that you've adopted from Mr. Hebert were filed for Duke Carolinas on September 30th and for Duke Progress on October 30th. Since that time, we've had quite a change in economic conditions. Would you agree?
I would agree with you on that.
You've talked about that some in rebuttal and supplemental testimonies. The COVID pandemic spread across the United States earlier this year, and an emergency was declared, followed by health and safety measures. And since that time, we've had quite a change in job rates and unemployment. Agreed?
Yes, and I guess it's one of those things where the virus and things like that, they don't know any borders, right? State borders, anything like that. So it's where it's kind of that the conditions that are going on across the whole country are also what's going on in North Carolina. So when it comes to, correlation and using say nationwide proxy group data, these companies market data and things like that, that's still applicable to say the companies in this case. Now that being said, the unemployment rates for US as a whole compared to North Carolina even though both of them are not great, they're not ideal, obviously, from what's been going on. North Carolina is actually faring better than the country as a whole. Now they've dropped. I think they only peaked out at 12.9% unemployment, and that was in April. And now in July, they're down to 8.5% as compared to the nation as a whole, which is 10.2% in July. So it's even though they're moving at the same rate, North Carolina fell less, had less unemployed percentage-wise, and has recovered faster than the country as a whole. So, it has hit, but North Carolina, even though everything's still very bad, and I'm not trying to say that it's not, they're less affected, but still affected, but less affected than what's been going on in the country.
So even at the better rate, we've more than doubled the unemployment rate in that time. I guess that's what you're saying in North Carolina. But relative to other parts of the country, it was worse at one point, but it's gotten so that it's a little better. That's true.
Yeah. So the American as a whole unemployment rate is triple of what it was, and it looks like in North Carolina it's only double. Which, I mean, it's orders of magnitude better in North Carolina, but like I said, it's still very high compared to what it was when we filed the case.
Now, are you talking about unemployment rates being paid out, or do you know, as opposed to unemployment? I think one of the issues could have to do with the tight unemployment policies. There's a substantial percentage in North Carolina that are denied, or don't you know?
It's from the Bureau of Labor Statistics, so whatever they're reporting.
I'd like to introduce an exhibit. At this point, it's not going to be as current because we filed these things a little while ago, but it's called AGO Exhibit 10 in your materials, and I don't see any page numbers on ours, but we didn't have nearly as many as the public staff.
Yeah, I have it.
Do you have that?
It's this guy here.
Yes. Oh, you're good. And you would, I'd like to mark that as Attorney General DeAscendis Cross-Examination Exhibit 1. Mark it down. So
It will be so marked, Ms. Force.
thank you. Mr. DeAscendis, would you agree with me that this, I'm going to tell you, this is from the website for the North Carolina Department of Commerce, and it provides some information about claims for unemployment in North Carolina and the percentage that were approved as of July 21st, 2020. Do you see that?
Oh yeah, updated July 22nd. Yes.
Yes, you're right. I'm looking at the graph on the bottom of the page, and if you flip over to the next page, it shows the pattern of unemployment claims that were filed between March 15th and July 21st. You see that?
Yes, ma'am.
And we have 1.2 million claimants during that period, according to that graph on the first place. Would you disagree with me that that's gone up since then?
I mean, I don't know, and I don't know. Yeah, I wouldn't know, and I don't know if it's been dropping or what the trend is. So I wouldn't know. Just I was trying to look up this, and I was also trying to look up if there's something equivalent for the nation, but I couldn't find either. So I'm sorry.
Okay, there's a lot of developments. It's a lot to try to keep up with. I think you testified that the real GDP has declined 5% during the period since COVID. Does that sound right?
That sounds right.
And aren't the economic impacts visible all around us? If you go into a parking lot for a bowling alley on a Saturday night next to a popular restaurant, there aren't very many cars, are there?
Well, you could say that for the same all around the country. I'm in New Jersey, and I went out, for the first time and since March, and there was nobody there, right? And like I said, if you're looking, this is now, it's not just the North Carolina experience, it's the nationwide experience, right? So it's not like North Carolina is any worse off than any other state or region in the country.
And if we're looking at the economic conditions that are facing customers in North Carolina or in the United States, either one, these are challenging times. Would you agree?
I would agree with that for sure.
Are you familiar with the decision in a settlement with Hawaiian Electric, HECO? They had filed a rate case about the same time, just a little before these rate cases for Duke were filed, and they've withdrawn the intent to increase rates in a settlement of the case as a result of the recession. Do you disagree with that?
I don't disagree, but that's the prerogative of management. It's not that there's any need for rate relief or anything like that.
Pardon me?
I said there isn't that's not saying that they don't need rate relief. They're just not doing it.
Okay. During the same time, Duke has experienced reduced sales to many of its industrial and commercial customers, right?
Yes, which would indicate a risk, correct?
And well, I suppose so. But during that same time, the consumption has gone up for residential customers as they are staying safer at home and as the summer heat has set in, right?
I don't know for sure, but I would assume so because I think that's generally what's going on.
Okay.
It's Carl. Our residential usage has gone up.
And those residential rates are a little bit higher per kilowatt hour, isn't that right?
Typically, yes.
So investors have seen increased riskiness as come through in your testimony, volatile stock prices, at least for a time. We had some discussion of that just a few minutes ago with Mr. Grantmeyer. Isn't that right? Things stabilized somewhat?
I think like Mr. Newland said, the credit spreads have moderated a little bit. So when there were 3 months that there was wider spreads, and then they went back down to normal between BAA bonds and A bonds. But the spreads between A bonds and AA bonds have stayed high, a little bit higher than what it was. And like this time last year, they were around 15 basis points. Now they're around 30 basis points. So there's still risk at the top end. So I wouldn't say, that there's still nothing has moderated yet. I don't think there's still a fair amount of expected volatility in markets. If you look at the term structure of volatility from CBOE, it still remains, even after my supplemental rebuttal testimony, they're still prognosticating a 50% increase in market volatility through next year, and I think into 2022. So I wouldn't say that anything is moderated. And like I was saying to Mr. Grantmeyer, a lot of the recovery has happened through 7 stocks. So if you're looking at that type of if you're looking at winners and losers, I think there's 7 or 8 winners and 400 losers. So I wouldn't say that any of the volatility has went away. I mean, it hasn't went away. It's not back to where it was when we filed this case.
So the VIX index is another measure, isn't it? Seems to me you said it was over 80 at some point in mid-March.
Yes, and like I said, it's a short-term 30-day measure, expected measure. I think when we had supplemental rebuttal, it dropped from 80 to 30, and now I think it's a little bit lower now. But
Say 22?
right, which is still higher than historical measures. Okay, historical measures are around 19, so they're still expecting over 20% volatility over the next 30 days. And I mean, that's still high compared to what it was at the beginning of the case. And like I said, the same CBOE, the people that put the VIX together, they have that further, the term structure of volatility, and they're still expecting it to be over 30 going through next year. So it's the one that you want to look at, the one that has a further lens is the term structure of volatility, and that's showing 50% higher volatility going forward.
But now when we're looking at where the yields are on Treasury, 30-year Treasuries, that's the risk-free rate. You indicated it's at 1.47. It's a little lower now, isn't it?
Yeah, about 10 basis points, but it was down to 1%. So if we're talking percentage terms, it's up 35% from what it was at the bottom. So, but like I said, all of this is it's still so volatile, and that's why you have to look at all kinds of measures of interest rates when you look at prospective interest rates or spot interest rates. The volatility of everything. Just you want to look at you want to look at multiple measures so you can see whether or not different pieces to the puzzle, I guess, to inform your judgment on what interest rates are going to be like. It's my opinion that they're not going to be 1% and 1.35%. My judgment would say that it's going to be higher than that once the volatility kind of tapers off. But right now we're not in a normal type situation here. So we're still in a very much volatile situation, and that's not to mention things on the horizon like the presidential election and things like that.
So when you're talking about volatility, though, while the rate has been what you're calling volatile, it's been low. The risk-free rate at least has been low, isn't that right?
Yes, and I think I explained
compared to a year ago, quite a bit.
Yeah, and I think I explained why in my supplemental rebuttal, and it's not a systematic in interest rates. There was a fall off the cliff type moment, and that's where people recognized the volatility and they scrambled to save capital. And when you go to risk on, risk off, if you're in risk, and then all of a sudden there's something that says you have a really big chance of losing a lot of money, you say, let me jump in the treasury bonds and hide until the volatility's over. And now let's move into, as the volatility subsides, you then move into equity. That's not a systematic decline of interest rates. It's an event-driven, volatility-driven flight to quality, as opposed to something that's been going on over time, gradual lowering of interest rates over time.
Okay, Ms. Force, I'm gonna stop you. We've come to the end of our day today. It's about 5 o'clock. We will end for the day. We will be back on the record at 9:30 in the morning. Please access the link as early as you can. I believe it will be open by 9 o'clock. So you should be able to log on, get your connection set up so that we can begin as close to 9:30 as possible. All right, thank you very much, and we will be adjourned. Thank you.
Thanks.
Thank you.